Welcome everyone. In this video I will read the full summons that BLSP is a part of. This is a similar video to the last BLSP summons video, except this will be the full summons. Please subscribe as it motivates me to continue putting out videos like this for your information. And please excuse any mistakes. Complaint. York Renewable Energy Partners LLC, YREP, Concord Energy Partners LLC, CEP, and Rhode Island Energy Partners LLC, RIEP, and, together with YREP and CEP, stakeholders, by and through their attorneys, for their interpleader complaint against Blue Sphere Corporation, Blue Sphere Prassas Capital LLC, Prassas and Leonite Capital LLC. Leonite together with Blue Sphere and Prassas, claimants, allege as follows. Introduction. 1. This interpleader action is brought under CPLR 1006A to adjudicate the respective rights of claimants to certain funds. These funds, totaling $1,071,250, are due to be paid by CEP and RIEP to Blue Sphere pursuant to limited liability company agreements entered into by and between YREP and Blue Sphere. Stakeholders, however, face competing claims from claimants with respect to the release of these funds and cannot determine, without hazard, how to proceed. The parties to Stakeholder YREP is a limited liability company organized under the laws of Delaware, with its principal place of business at 767 Fifth Avenue, 17th floor, New York, New York 10153. YREP is the majority owner of Stakeholder CEP and RIEP. 3. Stakeholder CEP is a limited liability company organized under the laws of Delaware, with its principal place of business at 767 Fifth Avenue, 17th floor, New York, New York 10153. 4. Stakeholder RIEP is a limited liability company organized under the laws of Delaware, with its principal place of business at 767 Fifth Avenue, 17th floor, New York, New York 10153. 5. Upon information and belief, Claimant Blue Sphere is a corporation organized under the laws of Nevada and has represented in prior filings with this court that its principal place of business is in New York, New York. 6. Upon information and belief, Claimant Prassas is a limited liability company organized under the laws of Arizona, with its principal place of business in Oro Valley, Arizona. 7. Upon information and belief, Claimant Leonite is a limited liability company organized under the laws of Delaware, with its principal place of business in Spring Valley, New York. Jurisdiction and venue. 8. This court has jurisdiction over this matter pursuant to CPLR 301 and 302 because claimants are residents of this state, have regularly conducted business in this state, and/or have availed themselves of this court's jurisdiction by filing lawsuits and/or issuing restraining notices in this state. 9. Venue is proper in this court pursuant to CPLR 503 because at least one of the parties resides in New York County. 10. A sum of $1,071,250 is at issue in this case, which exceeds the monetary threshold for the Commercial Division, New York County pursuant to Section 202.70A of the Uniform Civil Rules for the Supreme Court.
Factual allegations. Background. 11. YREP is an investment management company that invests in a variety of different industries, including the renewable energy space. 12. Blue Sphere is a corporation that has sought to develop or acquire projects with clean energy technologies, including waste-to-energy facilities. Blue Sphere previously held all of the interests in 2 highly specialized biogas anaerobic digestion facilities that were under development to transform waste into energy in Charlotte, North Carolina, the NC facility, and Johnston, Rhode Island, the RIEP facility, and, together with the NC facility, the facilities. 13. In 2015, YREP took a majority ownership stake in the facilities. In so doing, YREP and Blue Sphere entered into an amended and restated limited liability company agreement of Concord Energy Partners LLC, dated as of January 30, 2015, and an amended and restated limited liability company agreement of Rhode Island Energy Partners LLC, dated as of April 8, 2015, collectively, the agreements. 14. Under the agreements, YREP is the majority owner of CEP and RIEP and controls and funds them. Conversely, Blue Sphere is the minority owner of CEP and RIEP, plays no role in their day-to-day management, and has not provided any funding since YREP's investment in 2015. CEP and RIEP in turn hold all the interests in companies that own the facilities. 15. Pursuant to the agreements, Blue Sphere is entitled to receive certain fees if and when the facilities achieve mechanical completion, as that term is used in the agreements. As of December 9 and 12, 2020, respectively, the NC facility and the RIEP facility reached this milestone given that I. Construction of the applicable equipment for the facilities was completed in accordance with plans and specifications. 2. Such equipment passed applicable testing. 3. Components of the facilities were ready to be tested and commissioned, and 4. Certificates of mechanical completion for the facilities had been executed by all appropriate parties. 16. As a result of the facility's achievement of mechanical completion, pursuant to Section 6.01 of the agreements, Blue Sphere is entitled to receive $1,071,250, the mechanical completion payment, consisting of $587,500 related to the NC facility and $483,750 related to the RIEP facility, which is net of $78,750 in non-resident withholding taxes attributable to Blue Sphere's fees with respect to the RIEP facility. The agreements provide that CEP and RIEP are to make the mechanical completion payment to Blue Sphere now that mechanical completion has been achieved. However, it is unclear whether Blue Sphere, Prassas, and/or Leonite should receive those funds given ongoing disputes among claimants and competing demands that have been made by them on stakeholders.
2. The disputes among claimants. 17. On August 6, 2019, Prassas obtained a $1,953,318.52 judgment against Blue Sphere in a federal court action in the Western District of North Carolina, Prassas Capital LLC v. Blue Sphere Corporation, case number 3:17 CV00131, in which Prassas had alleged that it was owed fees for advisory work performed for Blue Sphere. The judgment was amended on February 6, 2020 to include pre-judgment interest of $871,057.78 as well as post-judgment interest of 1.94% until satisfaction in full. As such, the total amount of the judgment before post-judgment interest is $2,824,376.30. The judgment has been duly recognized by the Clerk of the Supreme Court of the State of New York, County of New York, Prassas Capital LLC v. Blue Sphere Corporation, case number 162,036 2019, Supreme Court NYCNTY, and Prassas registered the judgment in the Southern District of New York in order to enforce it, Prassas Capital LLC v. Blue Sphere Corporation, case number 1:20MC00280 SDNY. The judgment remains unpaid. 18. On January 7, 2020, pursuant to CPLR 5224, Prassas issued an information subpoena with restraining notice to an affiliated entity of YREP, York Capital Management, York. The subpoena included questions regarding any transactions in which Blue Sphere was or would become entitled to money. York responded to the subpoena by, among other things, identifying YREP, CEP, and RIEP as well as the payments that would be due to Blue Sphere upon achievement of mechanical completion at the facilities. 19. Thereafter, Prassas issued restraining notices pursuant to CPLR 5222B to CEP and RIEP on February 7, 2020, and to YREP on January 8, 2021, which prohibited payments to Blue Sphere for a period of 1 year or until Prassas' judgment against Blue Sphere was satisfied. Similarly, on February 27, 2020, pursuant to Prassas' request, writs of attachment were issued to CEP and RIEP by the Superior Court of the State of Delaware for New Castle County, which addressed any funds belonging to Blue Sphere that CEP and RIEP currently possessed or anticipated receiving. 20. As a result, once a determination was made that mechanical completion had been achieved at the facilities, stakeholders were faced with competing claims from Blue Sphere and Prassas for the mechanical completion payment owed to Blue Sphere. 21. Accordingly, on January 7, 2021, counsel for stakeholders sent a letter to counsel for Blue Sphere and Prassas advising them that facilities had achieved mechanical completion. 2. Blue Sphere is entitled to the mechanical completion payment pursuant to the agreements. 3. The mechanical completion payment could not be made to Blue Sphere due to the restraining notices issued by Prassas. 4. Unless Prassas and Blue Sphere were to provide a joint written instruction as to whom and in what amount the mechanical completion payment should be made, an interpleader action would need to be filed. And, vi. In the meantime, the mechanical completion payment had been placed in a segregated bank account and would remain there until a joint written instruction or a court order was received. The mechanical completion payment remains in that segregated bank account pending a decision by this court. 22. On January 8, 2021, Counsel for Prassas sent a letter to Counsel for Blue Sphere, copying Counsel for Stakeholders, requesting that Blue Sphere execute a joint instruction directing that the mechanical completion payment be made to Prassas. 23. On January 12, 2021, the third claimant entered the mix. On that date, YREP received a letter from counsel to Leonite stating that Blue Sphere is purportedly indebted to Leonite in the total amount of $2,260,855.02 plus collection costs, resulting from certain loan agreements between Leonite as lender and Blue Sphere as borrower. 2. Leonite is a first lien creditor of Blue Sphere. 3. The funds representing the mechanical completion payment must be turned over to Leonite. And 4. If Prassas insists that it is entitled to the mechanical completion payment, then Leonite would be forced to intervene under CPLR 5227 or to bring a special proceeding under CPLR 5239. 24. Now faced with 3 competing claims, on January 19, 2021, Counsel for Stakeholders sent a letter to Counsel for Blue Sphere, Prassas, and Leonite, requesting that such claimants jointly instruct stakeholders in writing as to which entity and in what amount the mechanical completion payment should be made. As noted in that letter, stakeholders remain ready, willing, and able to make the mechanical completion payment. However, we are not in a position to determine the accuracy of any of the entity's competing claims. The letter further stated that, absent a joint written instruction from claimants, we will be forced to file an interpleader action naming Blue Sphere, Prassas, and Leonite as claimants, seeking direction from the court on how to proceed. 25. On January 20, 2021, Counsel for Prassas sent a letter to Counsel for Leonite, copying Counsel for Stakeholders in Blue Sphere, rejecting Leonite's assertion that it has priority over Prassas with respect to the mechanical completion payment due to Blue Sphere. On the same date, as part of its action in this court, Prassas Capital, LLC v. Blue Sphere Corporation, case number 162,036 2019, Supreme Court NYCNTY, Prassas issued a subpoena duces tecum to Leonite and a deposition subpoena to Leonite's chief investment officer. 26. Blue Sphere was copied on the above-mentioned correspondence but has not informed stakeholders as to its position on which entity should receive the mechanical completion payment, although Blue Sphere previously claimed that, pursuant to the agreements, the mechanical completion payment is owed to it. 27. In light of the foregoing, stakeholders face competing claims and, as such, cannot determine how to proceed without placing themselves in peril. In this regard, Blue Sphere is owed the mechanical completion payment under the agreements. Prassas claims it should receive these funds given its judgment against Blue Sphere, and Leonite claims that it is a first lien creditor of Blue Sphere and that the funds should be paid to it. All 3 claimants have filed, or threatened to file, some form of proceeding or action in support of their claims. 28. Attempts to achieve a consensual resolution through requests for joint payment instructions have been unsuccessful, and stakeholders are neutral and have no interest in the disputes among claimants. Cause of action. 29. Stakeholders repeat and re-allege the allegations of paragraphs 1 to 28 of this complaint as if fully set forth herein. 30. The mechanical completion payment is subject to conflicting claims of interest and ownership, and stakeholders may be exposed to multiple liabilities as a result of such adverse claims with respect to the mechanical completion payment. 31. Stakeholders have no interest in the mechanical completion payment, X.E.P.T, to ensure that it is paid and distributed to the rightful party or parties. The mechanical completion payment, totaling $1,071,250, has been placed in a segregated bank account, and stakeholders are prepared to pay this amount upon an order from this court. Prayer for relief. Wherefore, stakeholders respectfully request this court to A. Direct stakeholders, pursuant to CPLR 1006F, to retain $1,071,250 to the credit of this action, to pay such amount into the court, or to deliver such amount to a person designated by the court. B. Discharge stakeholders, pursuant to CPLR 1006F, from any and all liability on any claim that has been made or may be made in the future with respect to the mechanical completion payment. C. Enjoin claimants from commencing or prosecuting any action or proceeding against stakeholders in relation to the mechanical completion payment. D. Require claimants to interplead and settle between and among themselves their respective claims and rights to the mechanical completion payment. E. Award stakeholders, pursuant to CPLR 1006-F, their attorney's fees and costs in connection with this action and order such fees and costs to be deducted from the mechanical completion payment. And F. Grant such other and further relief as this court deems just and proper. And that is about it. That is the end of the summons. Remember, these videos are for entertainment and information purposes only. Thanks for watching and see you in the next video. Serenity now. Serenity now.